Hello and welcome to the Tennessee Informer. I'm your host, Dave Vance. Our guest tonight is Alex Newman, an award-winning international journalist, educator, author, speaker, investor, nationally syndicated radio host, and president of Liberty Sentinel Media. He writes for the Epoch Times and the New American as well as other publications. But first, it's time for updates and announcements. If you have an announcement from a conservative organization that you would like announced on this show, please send the information to tninformer.tv@gmail.com the Friday before the show. The Henry County Republican Party will meet Thursday, January 18th at Tom's Steak and Pizza, 2501 East Wood Street in Paris at 7 p.m. Meet for dinner at 6 p.m. if you're interested. Candidates for the county caucus on February 24th, whether declared or potential, are encouraged to attend and speak. Make sure you watch the Facebook page for the county GOP on this. We have some bad weather. They may have to reschedule. If you want our state to step up and push back on our overreaching, often unconstitutional federal government, visit tncss.weebly.com and learn more about the legislation we hope to get passed this session that creates multiple processes for nullifying unconstitutional federal actions. The SEC of the state GOP recently passed a resolution in support of this legislation, as have the county commissions in Jefferson, Sullivan, and Roane counties. More are in the works. Additionally, TNCSS has coordinated for Chris Ann Hall to appear live Saturday, February 24th from 10 to 12:30 at the Dynamic Ballroom and Performing Arts Center in Mount Juliet, Tennessee. This is a free event, but the seating is limited. You must RSVP. Go to the events tab on tncss.weebly.com for more details. Chris Ann will be focusing on the issue of nullification. Now to our guest. Alex Newman is an award-winning journalist, as I mentioned earlier. He's written for a wide array of publications in the United States and abroad. He currently serves as a contributor to the Epoch Times, WorldNet Daily, Freedom Project Media, the New American Magazine, the Law Enforcement Intelligence Brief, and more. His bylines and writing have been featured in major newspapers and publications across the United States and the world. He has been featured many times on Fox, Newsmax, OAN, TBN, CNN, and all of the major conservative radio talk shows. Alex has authored and co-authored several books and serves as a director for multiple organizations in the fight for faith, family, and freedom. He's worked in a wide array of campaigns, ranging from political campaigns for Congress to marketing campaigns for nonprofit groups and international businesses. Alex has lived in 8 countries on 4 continents and speaks multiple languages fluently and more at varying degrees of proficiency. His work has been cited by governments and major media outlets around the world. He's a frequent speaker at conferences and churches across America and around the world as well, altogether having reached tens of millions of people with the message of faith, family, and freedom. Happily married and has 5 children. Along with his family, he currently splits his time between various places, including Europe and the United States. Hey, thank you so much for being on with us tonight, Alex. How are you doing?
Doing great. It's an honor and a pleasure to be with you. Thank you, Dave.
It's an honor to have you on. And I know your schedule is crazy, so I really appreciate you making the time.
Well, it's an honor to be here. Thank you for what you're doing.
Well, thank you. So tonight we're going to talk about some common objections to nullification, but we're going to use a recent article written by a retired lawyer here in Tennessee in a publication called Law and Liberty. I asked Alex to read the article and give his thoughts on different arguments and points made. In this recent article from a retired California lawyer now residing in Tennessee, asked the question, is nullification an option? His conclusion was that it was not a legitimate option. He made the following statements in his articles. Opponents of the Leviathan will find no succor in the imagined panacea of nullification. He also said the framers never squarely addressed nullification in Federalist Number 46. Madison suggested that the dual sovereignty of the states would serve as a check on federal authority exceeding its proper bounds. The essence of Federalist 46 is pro-ratification happy talk directed at suspicious states, placating them with assurances that, as a practical matter, federal usurpation, the annihilation of state governments, was not possible. In this and many other respects, the skeptical and pessimistic anti-federalists were prescient, meaning they were correct in their prediction that it would go badly. So, Alex, what are your thoughts? Do you think that nullification is an imagined panacea?
I don't. I think it is kind of like the emergency option of last resort. We don't want to just do this for small or trivial things. But when we see, as the founders explained in the Declaration of Independence, a long train of abuses aimed clearly at making us all into slaves, we have to respond. And we want to respond using lawful means. The reality is, if you look at the Constitution, if you read the Constitution, this was a compact. This was an agreement between we the people and the sovereign states that existed at the time. And today we have even more. Each one has acceded through the proper process. But it was an agreement of these states to come together and delegate a few responsibilities to an agent, the federal government. Those responsibilities were listed out clearly. And anything beyond those responsibilities is a violation of the contract. It's a violation of the compact. And so for the federal government to say, yeah, you states created me. Yeah, you put strict limits on what I could do according to the compact, according to the contract that even brought me into existence. But now you can't challenge what I'm doing. You cannot refuse to honor your end of the deal, even though I'm not going to honor mine, is totally preposterous. And it wouldn't be acceptable in any other business deal. Suppose that two companies were to sign a contract. One of the signers on the contract were to say, well, I'm just going to totally ignore the contract. I'm not actually going to build you a house, but you have to honor your side of the contract. You have to pay me for the house. I'm just not going to build it. I mean, everybody with a brain would say, yeah, that's not legitimate. Of course, I'm not going to pay you for a house you didn't build. Well, that is the same principle at work here. The states agreed to join the union on the condition that this contract was going to be respected, that the responsibilities that have been delegated to the federal government would be the responsibility of the federal government, and that all other powers were going to be reserved to the state governments that make up the union. Clearly, we have a federal government that is totally in violation of that contract, and it doesn't just makes sense that the states would not comply with illegal and unconstitutional dictates. It really is a requirement. As Madison and Jefferson explained in the Virginia and Kentucky resolutions, this is the rightful remedy for the kinds of abuses that we're seeing right now. And of course, even Alexander Hamilton, the ultimate federal supremacist among the founding fathers, explained that when you end up in a situation like this, of course, the states are not going to cooperate with the officers of the Union. That's what we need to be pushing for.
Yeah. And so his argument that the framers never squarely addressed nullification, I mean, he's ignoring quite a bit in the Federalist Papers when he says that, right?
He absolutely is. Yep. And, he kind of superficially addresses a few of the things. And he, to his credit, he even brings up the Virginia and the Kentucky resolutions. But he kind of just says, yeah, they said this, but, let's just move on past it. And that's not appropriate. When you talk about the framers, arguably, the two most important framers were James Madison and Thomas Jefferson. Right? Thomas Jefferson, of course, was the lead author, the main individual responsible for the Declaration of Independence, and James Madison is, of course, known as the father of the Constitution. Who would you expect to know more about the founding documents, about the way the system was intended to operate, than the father, the framer of the Declaration of Independence, and the father of the Constitution? Well, those are the men who wrote the Virginia and the Kentucky resolutions, where they openly advocated nullification, where they openly said this was the rightful remedy to unconstitutional abuses by the federal government. So the argument that the framers didn't address this, or the argument that the framers didn't intend for this, unfortunately, is not sound. Anybody can go read these documents themselves, and really they should, because this is really an issue now of whether we are going to live as slaves under a federal government with absolutely no limits on its power. And when you read this criticism by this retired lawyer, he kind of concludes with, we don't have any options. We just have to suck it up and be slaves. And frankly, that is completely unacceptable to anybody who values their freedom. We cannot think like that. We cannot tolerate that. And again, go back to the writings of the founders. Go back to the Federalist Papers. These things are very clear.
Yeah. And he references the Federalist Papers and 46 in particular, and he described 46 as happy talk with no real relevance. And basically he was trying to say, hey, look, this was just the politics of the time. The people who wanted the Federalist Paper, or wanted the Constitution approved, that's what the Federalist Papers were all about. And that really, you can't, he's almost saying you can't take the Federalist Papers serious. I mean, that's how it came across to me. Now, he's correct in stating that the Anti-Federalists were spot on with a lot of their concerns. But the Federalist Papers, if I understand it correctly, the Supreme Court, the vaunted Supreme Court, they even occasionally at least look at, and they are legitimately considered, they're considered legitimate sources for the court to reference. Am I correct on that?
You're absolutely correct on that. And if we can't consider the Federalist Papers in considering the meaning of the Constitution, the Constitution essentially has no meaning. I mean, this is the argument of the progressives, that it's a living document. And, when the Constitution was being ratified, these Federalist Papers were the arguments that the authors and the framers of the Constitution were making to encourage people to support it. Right. So if we can't take that as evidence of the intent of the people who wrote it, what can we take as evidence, right? There is nothing. So the Federalist Papers obviously are one of the primary sources of information that we have to consult when we try to understand what was the intent of the people who wrote this, what was the intent of the framers and the drafters of these documents. And so to suggest that the Federalist Papers are happy talk, he says that they are pro-ratification, happy talk directed at suspicious states. That implies, in fact, not very subtly, that the Founding Fathers were lying, dishonest propagandists who were willing to use deception and happy talk to get states to ratify their document. And frankly, I'm not ready to look at the Founding Fathers like that. And if the states ratified the Constitution under false pretenses, well, we've just opened another major can of worms. And then we need to go back and say, well, were the states defrauded into signing on to this suicide pact? Because if that's the case, well, if you enter into a contract by fraud, that contract is null and void in any case. You're not bound to obey the terms of it. So either way, they're in checkmate here.
Yeah. And a lot of the Federalist Papers also, as I understand it, were written in a direct response to the arguments made by the Anti-Federalists, whether they were the Anti-Federalists at the convention or some of the Anti-Federalist authors that didn't get near as much press as or they're not as remembered as well as the Federalist Papers. But a lot of those arguments in the Federalist Papers, they would reference some of the comments made by Anti-Federalists and try to just say, that's not a legitimate description of what the Constitution does. So they were directly addressing these claims.
They were. Yep, they were. And, we've been talking about Federalist 46. I think it's worth mentioning a few things about it. So Federalist 46, this was, of course, written by James Madison, again, the father of the Constitution. And he actually explains that if the federal government were to go beyond the bounds of what it's allowed, he says the states might use refusal to cooperate with officers of the Union. Says that these states joining together, they would present obstructions which the federal government would hardly be willing to encounter. And so what James Madison is saying here is that if and when the federal government were to, and they, for whatever reason, maybe naivete, did not imagine that the federal government would ever want to do that. They would never usurp all these powers. Clearly, that was not the case. So he was wrong on that. But he explained that if the federal government were to exceed its bounds, if the federal government were to go beyond the bounds of what the Constitution permits, what the states delegated to the federal government, then the states would actually resist, and that would prevent it, right? And so to say, well, that's just happy talk, that has no bearing. Look, this is the primary man responsible for the U.S. Constitution. If he cannot be trusted as a source on what the Constitution is supposed to mean and the proper response of the states to these kinds of abuses, then nobody in the world can, certainly not federal judges.
Yeah, and the fact that he is the guy who gave his word that the first order of business in the new Congress would be taking up a Bill of Rights, which was one of the big concerns. Without his assurance of that, then there were key states that were not going to ratify. And some of the states in the ratification process, they put clauses in their responses that, hey, look, we reserve the right to do whatever we do, and this is my paraphrase, do what we need to do if the federal government, breaches this contract.
Yeah. And, you know, the 10th Amendment is so explicitly written, right? The Constitution would have meant the same thing without the 10th Amendment, right? And they talked about this in the Federalist Papers. You actually don't need a 10th Amendment because it's obvious. If a power was not delegated to the federal government, then of course the federal government doesn't have that power. Of course the federal government cannot exercise that power. And that was kind of like universally understood at the time. And a lot of them said, why would you need a 10th Amendment? I mean, there's never going to be a time where people are so stupid that they would imagine that the federal government can do things that the states didn't authorize them to do. We don't even need that, right? It was just so obvious. Well, thankfully for the doofuses of our generation, if you will, after multiple generations of government education, we seem to have forgotten basic principles of logic and even the meaning of words. They spelled it out very clearly. Any powers that are not delegated to the federal government, to the United States, are reserved to the states and to the people. And so if the federal government is exercising a power that was not delegated to it, the states have not just a right, but as James Madison and Thomas Jefferson said, a duty to resist this. And this is something that has been used very successfully many times throughout our history. And, you know, the Anti-Nullification Act, the individual, the retired lawyer, doesn't use this argument, but many left-wing anti-nullification activists and advocates try to act like nullification is somehow racist or that it was associated with the southern states. In fact, it was the northern states that were using nullification of unconstitutional federal statutes that were angering the southern states. It's one of the reasons South Carolina was so upset with the Union, is because northern states were nullifying unconstitutional federal laws like the Fugitive Slave Act, purporting to require them to run around chasing slaves who had run away from southern plantations. So this was clearly understood at the time. The Supreme Court has even upheld these things many times in the past, and it's really time that Americans reestablish this as just basic common sense. If the federal government has usurped powers that do not belong to it, the states are not only not bound to obey, they are bound and have a responsibility to resist actively.
And for the next one, what Madison wrote in the Federalist is not controlling in any event. This is what the author says. Does the Constitution, either in its text or as interpreted by the Supreme Court, allow states unilaterally to disregard federal law on the grounds that they believe the law is unconstitutional? The doctrine of judicial review and the court's later assertion of judicial supremacy in Cooper v. Aaron from 1958 complicate the analysis, at least if nullification is used in the sense of defying or ignoring federal law. Cooper v. Aaron dealt with a form of nullification, the massive resistance to a desegregation ordered by Brown v. Board of Education, 1954, and unambiguously rejected it. So the author equates the text of the Constitution with the interpretation of the Supreme Court, as do most judicial supremacy advocates, based on a distortion of Article 6, in my opinion. If that were correct, then would that not make Article 1, Section 8, the Bill of Rights, and especially the 9th and the 10th Amendment, meaningless?
It's exactly what it does, David, and there's no question about it. It creates exactly what Thomas Jefferson warned about, which is a judicial oligarchy. If we accept that interpretation, which is preposterous, by the way, but if we accept that interpretation, we have no need for a constitution. Why should we have a constitution? We have total and complete rule by 9 unelected judges in black robes. We have no need for a constitution. We have no need for a Congress. We have no need for a president. We have no need for anyone else except these judicial overseers of every element of our lives. And that is so repugnant to anything constitutional, to even basic common sense, that it's hard to imagine somebody seriously entertaining that idea. And I believe if you were to explain this even to a progressive, big government, federal supremacist, they would come away understanding the same thing. If we accept the proposition that the Supreme Court is the final authority on anything and everything having to do with the Constitution, that means functionally we have no Constitution. That means the decision of 5 individuals trumps the plain reading of the text. And in that case, we do not have any longer the rule of law. We do not any longer have any rights guaranteed by the government, which in fact was the purpose of the government, according to the Declaration of Independence. And it's such a ludicrous idea that it's hard to believe that people seriously put this out there. But, you know, after a lot of years of training as a lawyer, you know, people come to some pretty silly conclusions.
Yeah. Well, and the sad thing is, this person, and I'm not, I haven't mentioned his name. I have a couple mutual friends. All in all, the guy is a certainly a conservative on most counts, but like most lawyers, probably 98% of lawyers, they are judicial supremacists. They think that's the way it has to be, and that just, to me, it makes everything else moot. Like I said, that if that's the way, we may as well change our oaths to, instead of uphold the Constitution, to, we pledge our oath to uphold 5-4 decisions of the Supreme Court. I mean, just shorten the oath. We don't need to say anything else if that's all it is.
And that's what these people are arguing, David. And I think it's an important point. Like you, I'm not making any personal attacks on this individual. I don't know him. I don't know anything about him other than this article that he has written. But this is what you find among so many of the people who have trained in our modern law schools, is that actually I have done this with, I can't even count how many lawyers now. Did you read the U.S. Constitution in law school? So far, I have had 0 lawyers say that they have read the Constitution in law school, except those who decided to read it on their own, not because it was assigned in class. Now, if the Constitution is the supreme law of the land, which is what the Constitution says, and as far as I know, nobody's overturned that yet, Supreme Court, we're looking at you. But if the Constitution is the supreme law of the land, in what universe could you get a law degree without having read the supreme law of the land? But what they do, and anybody who's been trained as a lawyer in pretty much any law school in this country today will say, well, we're studying case law. We're looking at the decisions of judges, which are based on the decisions of previous judges, which are based on the decisions of previous judges, which are then based on the decisions of previous judges. And there's no problem with looking at previous decisions by judges. But when you get to the point where you say previous decisions by judges are more important than the Constitution that we, the people, and the states used to create this entity called the federal government, you're now in la la land. I mean, it's just absurdity. And like you pointed out, why would we then even bother swearing an oath to the Constitution? We could just swear an oath to what 5 out of 9 Supreme Court justices think and just be done with it, just dispense with the whole farce. So it's ludicrous. We cannot accept that. And any lawyer who thinks otherwise, I think, really needs to ask themselves some fundamental questions. What happens if 5 out of the 9 Supreme Court judges say you can't speak freely anymore? What if they say you can't own property anymore? What if they say you have to die because we don't like you? And if you just extrapolate a little bit from what you're saying, you'll realize the incredible absurdity of this proposition.
Yeah. Well, there's some real life absurdity. You look at the marriage decision. Well, you look at the abortion decision, Roe v. Wade. I mean, they created that out of whole cloth. Marriage decision, I mean, they essentially created that, and just 2 years prior, they said, hey, that's on the states. That's never been federal, a federal issue. And we have something going on in Tennessee today. You may have heard about it. I know it's in other places too. These after-school Satan clubs, and they're basically being told, well, because you allow a Christian or other religious entity to have after-school clubs there, then that means you have to allow a Satan club, because the Supreme Court at some way back said that to have certain religious things happen on school grounds at a school or with school personnel, that constitutes a violation of the First Amendment. So that's another perverted distortion of case law that now means we're allowing after-school Satan clubs in our schools. I mean, that's just insane.
It is. It is. And it's going to go further unless and until people reject the silly arguments made in this paper that we're talking about. Right, right now, you have a case. You have an abortion clinic that popped up in New Mexico. I believe it's called the Samuel Alito's Mom's Satanic Abortion Clinic. And they have filed lawsuit. They are arguing in legal filings that they have a religious right under the First Amendment to sacrifice babies to Satan as part of a satanic ritual. If the First Amendment, in the opinion of the Supreme Court, means that you can murder babies to Satan because of the First Amendment, frankly, I think we'd be better off not having a country at all. It is totally insane. That was never the intention of the Founding Fathers. But it's not out of the question, right? We now live in an era, and you pointed to some excellent examples. We now live in an era where it has been accepted by the federal judiciary and by the bulk of the lawyers graduating from our law schools that whatever those 5 people on the Supreme Court say is the supreme law of the land instead of the Constitution. And so at some point, we're going to have to say, no more of this. And I don't know when that point will come, but at some point we're going to have to say that, right? We should have said this a long time ago. When they said, for example, in 1962, 1963, that we couldn't have Bibles in school, that we couldn't have prayer in school because of the First Amendment, the states should have said, wait a minute, that's absurd. Wait, where do you get that, right? First of all, when the First Amendment was written and ratified, most of the states had established churches.
Yep.
So you'd have to be a moron to believe that the people who wrote that imagined that you couldn't have a Bible or a prayer in school, right? I mean, clearly, that was not what they intended with the First Amendment. Second of all, the First Amendment says Congress shall make no law.
Right.
It says nothing about the state of New York, which was one of the cases involving the prayer. It says nothing about the school district in Pennsylvania, which was the case involving the Bible. So this was so obviously ludicrous. The states should have said at that time, all right, that's a nice opinion. Thank you, Supreme Court. We're going to be throwing it in the trash, and we're going to be continuing to pray and read the Bible in this state because we are Christians, and that is what we are going to do. They didn't do that. So in 1973, the Supreme Court says, well, we found in the penumbras a right to privacy, which means you can massacre your babies. The state should have said, that's a really silly opinion, Your Honor, and we are not going to be respecting it. In fact, if anybody murders babies in this state, they are going to be put to death or put in jail for the rest of their lives. And, if you disagree, you can come and force that decision with your army, right? And we didn't do that. And so they got even bolder to the point where in 2015, they invented completely out of whole cloth a right to a homosexual marriage. And unless and until people, and really this has to be through the states, unless and until we the people acting through our states say, look, that's enough of this. You people are not God. You people are not the supreme law of the land. You people exist at the pleasure of we the people as defined in the Constitution. There's your job description. We're going to continue with this extremism until we get to the absurd point where they might actually rule that you have a First Amendment right to murder babies to Satan as part of religious freedom. And so, folks, watch out, right? We cannot continue going down this path without ending up like Nazi Germany, Soviet Union, Cambodia under Pol Pot. That's the direction we're heading. We're not there yet, right? And I don't mean to imply that we're there yet, but we're on the way to that, where the decisions of a tiny handful of lunatics could result in the most barbarous acts of savagery imaginable, all under color of law. And the primary remedy, the main remedy for this, as the father of the Constitution explained, the rightful remedy is for the states to step in and say, no, that's not going to happen in our state.
So how can Cooper v. Aaron in 1958 be construed to make nullification illegal?
Well, that's their interpretation of this decision. In this decision, they said, I've got it in front of me. The Chief Justice, they cited Chief Justice Marshall, the fundamental and paramount law of the nation. So they went back to Marbury and Madison, which was actually the case that first established this idea of judicial review, the idea that the Supreme Court would make itself. And this was a power that was usurped by the Supreme Court early on in our history. And I actually think it's a really good starting point for this discussion. When the Supreme Court usurped these powers in Marbury versus Madison, did they have the proper authority to make themselves the supreme arbiters of the Constitution? And the answer is no, right? How do I know that? Because I've read the Constitution, right? The powers, the jurisdiction, the scope of the powers of the federal judiciary is outlined quite clearly in Article 3, and nowhere will you find in there any delegation of authority for the Supreme Court, which of course represents one side of the contract that makes up the Constitution, would be the final arbiter, right? And nobody would have accepted this in any other context, right? Would the states have ratified a constitution if they knew that the entity they were creating when they ratified that constitution would determine for itself what was and was not allowable in that contract? Well, it's like, let's go back to the example that we started with. If I hire you to build me a house and we sign a contract that says you build me a house, I pay you money, but the only person who has the authority to interpret and understand what this contract means is one of the parties, the other party would be a total idiot to sign such a document. And that is essentially what Marbury versus Madison does. It says, the federal government, really the Supreme Court, has the sole authority to determine what is and is not constitutional. That's an illegitimate exercise of power. And so to ultimately remedy this, we have to go back to that very question and say, no, the Supreme Court is not the final arbiter on that. The states have a right to interpret and understand the Constitution, just as the federal government, the agent created by that Constitution, has the authority. And that's what the Founding Fathers were thinking when they created our Constitution. They divided power horizontally, which we all learn in civics, the three branches of government acting as checks and balances against each other. But what they're losing is the division of power between the dual sovereigns, the state and the federal government, where each one is meant to act as a check on the other. Now, the federal government does have some authority over states on all the matters that have been delegated to it, right. And also the states surrendered certain powers, like the form of government. Right, a state cannot declare itself to be a monarchy. A state cannot declare itself to be a democracy. A state cannot declare itself to be an oligarchy. The federal government has an obligation to guarantee to every state in the union a republican form of government. So the federal government, under the compact, under the contract, does have some authority to tell the states what to do within these very limited and defined spheres. It does not have unlimited authority to tell the states what to do, which is the power that it has usurped for itself. It didn't usurp that power in Marbury versus Madison, but that wrong decision led little by little to the point we find ourselves in today.
Yeah. And it is strange, and I can't remember which Federalist paper, but it talked about the judiciary basically it would be the weakest of the three branches of the federal government because it didn't have the power of the sword and it didn't have the power of the purse. And of course, the Supreme Court, think about it, the Congress can and has limited their appellate jurisdiction. Now, by the Constitution, they can't limit their original jurisdiction, but they can limit and have limited. So I don't know how a branch of government that is still technically under the control of Congress to a great degree, why everybody thinks that is the branch that gets to basically be supreme on all decisions and on all topics. I don't quite get that.
Yeah, I think part of this, unfortunately, Dave, is that Congress kind of likes this arrangement, right? We unfortunately have we've ended up with the Congress that we deserve, right? At least prior to maybe the more recent elections, where there's a lot of questions about the legitimacy of those elections. But if you go back a little further, a lot of these guys were legitimately elected. These were people who the American people elected to represent them. And even though they didn't admit these things on the campaign trail, I think a lot of them are quite happy to allow the Supreme Court to permit the slaughter of unborn babies. And so when the Supreme Court says you can mass murder your babies because you have an imaginary right to privacy that we found in the penumbras of the Constitution, well, then they want to pretend to be against it, but they don't really believe that it's wrong. And so they say, well, the Supreme Court has ruled, the Supreme Court issues the law of the land, therefore we can't talk about it. But ultimately, and I think this is a really important point to emphasize, the Congress also has the ability, and actually I would argue the obligation, to step in here and hold these people accountable. They should have done it in the early 1960s with these crazy rulings on the schools. They should have done it in 1973 with the crazy ruling on the massacre of unborn children. They should have done it in 2015 with this abomination of a decision on inventing so-called homosexual marriages. And part of this is, of course, the ignorance of the American people. Yep. You can actually trace a direct line, right? If we had not been dumbed down for a few generations prior to the 1960s, no sensible American would have ever believed that the Supreme Court had the authority to remove Bibles out of our schools, right? They never would have believed that lie, because they would know the Constitution, they would know basic common sense, they would know the meanings of words. And so the reason the Supreme Court has been able to usurp these powers is because the American people have remained ignorant. I might say have been made ignorant. They have elected state officials and congressional representatives who want to tolerate this at the very least, if not encourage it. And so really one of the solutions, of course, nullification is key, but another one of the solutions is for Americans to put pressure on their elected officials in Congress to then hold the judicial branch accountable. You can start impeaching judges. You can start censoring judges. You can start removing judges. We have lots of remedies here. And they can also limit the jurisdiction of the Supreme Court even more than it already is limited. So.
Yeah, and like I said, they can and they have, but they generally don't, because like you said, they like to be able to say, hey, I agree with you, but the court has spoken. There's nothing I can do. And oh, by the way, that's why it's so important that we get the right guy in as president so that he can make appointments, the right appointments to the Supreme Court, so they can fix everything. And that really has not worked out for us. I mean, we did get, what we've gotten from Trump's choices is a very mixed bag, So,
Yeah.
but you're right. They like that arrangement because that way they can pass the buck.
Yep. But to be clear, it is an unconstitutional arrangement. It needs to stop. And I do believe that they have pushed Americans to a point now where they're very frustrated and they're looking for solutions. So I think the key here is we've got to educate the American people on these issues. We've got to educate them about what the Constitution says. Yeah. Right? We have the solutions to these problems. We don't need to change the Constitution to fix these problems. We don't need to throw it out. We don't need to really do anything radical other than just have the American people understand what the Constitution says, and then have those American people lean on their elected representatives at the state and federal level to make sure that that Constitution is followed. Every one of our elected officials puts their hand on a Bible, or supposed to, and swears an oath to that Constitution, not to the Supreme Court. And so the solution then is to get that enforced, and that will happen when enough Americans understand that this lawlessness is a direct result, not of problems in the Constitution, but in a lack of constitutional enforcement.
Absolutely. Article 6 of the Constitution makes the Constitution the supreme law of the land. In 1803, Chief Justice Marshall, speaking for unanimous court, referring to the Constitution as the fundamental and paramount law of the nation, declared in the notable case of Marbury versus Madison that it is emphatically the province and duty of the judicial department to say what the law is. This decision declared the basic principle that the federal judiciary is supreme in the exposition of the law of the Constitution, and that principle has ever since been respected by this court and the country as permanent and indispensable feature of our constitutional system. Every state legislature and executive and judicial officer is solemnly committed by oath taken pursuant to Article 6, Clause 3 to support this Constitution. No state legislator or executive or judicial officer can war against the Constitution without violating this undertaking to support it. Chief Justice Marshall spoke for unanimous court in saying that if the legislatures of the several states may at will annul the judgments of the courts of the United States and destroy the rights acquired under those judgments, the Constitution itself becomes a solemn mockery. Clearly then, under the authority of Cooper v. Aaron, individual states cannot simply defy federal law or even the Supreme Court interpretation of the Constitution, no matter how sincere or valid their objection to it. If a state believes that a federal statute or executive order violates the Constitution, the remedy is to challenge it constitutionally in court, as state attorneys general regularly do. Defiance of the law, the aggressive form of nullification, is not consistent with the rule of law. They are free to participate in and influence all levels of government, but only within the established institutional framework and using the recognized tools of legislatures, executives, and courts. This may not guarantee results, but it is the only legitimate path forward. Nullification in the sense of repudiating or defying duly enacted federal laws is a futile act that at best will waste time and create disappointment. At worst, it could lead to armed confrontation of the type Andrew Jackson threatened in 1832 and 33. After the events of January 6, it should be clear that going rogue is not a viable strategy in the 21st century. In order to preserve constitutional government, Americans must work within the Constitution and its processes. So my questions from this portion of his article to you are, does past deference to the court give validity to the claim of supremacy? I mean, in other words, we have, for the most part, given deference to the court over our history. But does that mean just because we've done that, number one, we should have, or that legitimizes the supremacy?
It absolutely does not, Dave. And actually, you skipped over one piece that he said there, and I think it actually encapsulates perfectly the brazen logical fallacy that we're dealing with here. He says right after quoting this decision, the Cooper versus Aaron, he says, in short, the Constitution means what the Supreme Court says it means. Yep. And the decision of an unelected 5-person majority is final and binding on the rest of the nation. So This is a logical fallacy, and any second grade student of logical fallacies would see this. It's called a tautology. Well, the Supreme Court said that it is the final authority on the Constitution. Therefore, the Supreme Court is the final authority on the Constitution. That is a logical fallacy that is very obvious and should be glaringly obvious to any student, even of the most rudimentary, basic level of logic. So what we're dealing with here is a logical fallacy. The Supreme Court declared itself to be the final authority, therefore it is the final authority. That doesn't work that way. And again, we can go back to what I said earlier. Just project the lines. What if the Supreme Court says that blue is actually orange? What if the Supreme Court says that you have an obligation to marry your cat? What if the Supreme Court says that if you're a Jew, you belong in a concentration camp? Right? It doesn't take long to recognize that this is an insane idea. And yet he says, that's the way it is. There's nothing we can do about it. Get used to it. And excuse me, but that is the mentality of a slave, right? And to go back to Article 6, because they pin all of this on Article 6, they never actually bother quoting the full text of Article 6 that is relevant in this case. Says any of the laws made in pursuance thereof. And so those are the key terms right there. Laws that are made in pursuance thereof are that means, in other words, they were made in pursuance thereof. They were made in accordance with the Constitution, under the authority of the Constitution, under a power delegated to the federal government under the Constitution. Those are, in fact, supreme.
Right.
So if the federal government has the authority to establish a post office, which it does, and Congress says, we're going to create a postal building here and we're going to name it after Nancy Pelosi because we like Nancy Pelosi a lot, and that's going to be the name of the post office, then that law is supreme. So, the state of Florida could not then say, well, we don't like Nancy Pelosi, and so we're going to rename that post office, or we're going to shut it down, right? The federal government has the authority under the Constitution. Florida agreed when it entered the Union that the federal government had the authority to establish post offices, and so therefore, that is a law that was made in pursuance thereof. Right. If the federal government were to say all Jews belong in concentration camps because we found something in the penumbras that really makes us think that we ought to get rid of the Jews, then we would have to say, no, sorry, Supreme Court, that's not the supreme law of the land because that is not in the text of the Constitution. That is absurd, and therefore Jews in Florida will not be put in concentration camps. Thank you very much. And if you try to put the Jews in concentration camps, we're going to be forced to handcuff you and take you down to county jail, and you're going to be put on trial, and a jury will determine your fate. Yeah.
And in pursuance thereof is directly linked to the necessary and proper clause. So
that's right.
In other words, necessary and proper clause is not a catch-all the way they use it. Okay, it has to be related to an enumerated power.
Precisely, right? And these are the very obvious distortions that the federal supremacists use to try to argue for unlimited power. They said general welfare. They said necessary and proper. I mean, these arguments are so basic that a first grader not trained in a law school would instantly see how absurd that is. Why would they have bothered writing a constitution if they thought Congress ought to be able to write any law that they thought was necessary and proper for the general welfare? Yeah. Why in the world would we have a constitutional convention? Just say Congress has unlimited power. They can do anything that they want to do. There'd be absolutely no reason to have a constitution. There'd be absolutely no reason to debate all these finer points. And so it's self-evidently ludicrous, Dave. And again, the problem is so many of these lawyers, they've gone through 3 years of training and they've been indoctrinated to believe this stuff, and they live in this little bubble, right? And all their friends who are lawyers think the same way, and they spend all day studying the case law, and then they go into court and they hear more about it. So they live in this little bubble where they're just immune to logic and reason and common sense. And so now it's our task as Americans, and I don't mean to generalize. There are plenty of decent lawyers who do understand the absurdity of this.
I don't know about plenty, but I'm sure there's some.
there are some, right? I should rephrase. There are some. And so we now as Americans need to grab this bull by the horns and say, look, you people need to come out of your bubble. You need to come back to reality. You need to recognize that these things that you're saying are absolutely insane, and this cannot be tolerated. A free people cannot accept that 5 guys in robes are going to rule over every area of our lives with no checks on their authority. That is, again, the mentality of a slave. It is completely unacceptable to a free people, and everybody, even lawyers, should be able to see that.
Even lawyers. So the legislators, whether you're talking federal or state, they take an oath to the Constitution. And so they have obligations to uphold that oath despite the opinion of the court. I mean, when it says when they take their oath, they're going to uphold and defend. So that would include defending it from the court, right?
Of course, absolutely, of course, and let's use the Jews example again, just an extreme example. You could think of a million of them, but I don't want to use something where anybody could say any wiggle room. I think pretty much everybody can agree that if the Supreme Court says we need to round up all the Jews and put them in camps, we're not going to do that, right? So why not? According to Aaron versus Cooper, what the Supreme Court says the Constitution says is supreme, and it's binding on the whole nation, according to this lawyer who wrote this text, according to the Supreme Court's own opinions. Well, would we accept that if if the Supreme Court ruled that Jews are bad and Jews need to be rounded up and put into concentration camps? No, we would not accept that, right? And I think even the most liberal, lefty, big government lawyer at the DOJ, Mary McCord, we're looking at you, would understand that that is ridiculous, right? And yet they're trying to argue that anybody who doesn't accept their interpretation is somehow a radical. That's ludicrous, right? If you're a state legislator, or a member of Congress, or even a state judge, or you're sitting on a state Supreme Court, you take an oath to the U.S. Constitution, and if you're a state officer, to your state Constitution as well. You don't take an oath to the opinions of the Supreme Court. And so if the Supreme Court says something, rules something that is clearly at odds with the Constitution, as they have been doing more and more in recent decades, your obligation, again, just read the text of your oath, is not to the Supreme Court's interpretation of the Constitution. It's to the Constitution itself. And, they try to gaslight us here. And, oh, you're not a lawyer. You don't understand this. I was like, look, I can read English. Okay. I understand basic grammar. I've got a dictionary. In fact, I've got Noah Webster's 1828 dictionary. So I know what these words meant back then, and I can consult that too. So I can understand the Constitution just as well, if not better, than you people with your robes and your 3 years of legal training. And when you make a ruling, or when you issue an opinion that flatly contradicts the Constitution, and worse, that threatens or jeopardizes or abuses the rights of my constituents, who I am supposed to be protecting, whose rights I am responsible for upholding, I then have an obligation to say, no, we cannot accept that. And you might even go one step further, right? Because a lot of these guys, including our soldiers, take an oath to uphold the Constitution from all enemies, foreign and domestic. Yep. Well, who would be a domestic enemy of the Constitution but somebody who tries to issue orders that are flagrantly in defiance of the Constitution? Right. So, state legislators, state judges, state officials need to understand you are not swearing a blind oath of allegiance to whatever 5 individuals may find themselves ruling in the majority on the Supreme Court. You're swearing an oath to a document that we, the people, through our state governments, have consented to be bound to. We have an amendment process. If somebody doesn't like the Constitution, we can amend it. We've done that many times in our history. And so there are ways. This guy says we just have to work within the political process to change. No, they have to work within the political process to change. If they don't like the Constitution as it's written, we have an amendment process for that. They can go to Congress and ask for an amendment, or they can go the other route. I prefer they wouldn't do that, but they have that option too. And then they can make changes to the Constitution so that when you swear an oath to the Constitution, you're swearing an oath to what they want. But if they want those changes, they have to do it constitutionally. They have to do it legally. And that means they need to pursue the constitutional amendments that they want to see, not just have 5 guys on the Supreme Court rule in their favor.
You mentioned the military, and we actually hold them to a higher standard than we do our legislators in a lot of ways, because under the law of military warfare, or the law of land warfare, you cannot use as an excuse, Sergeant so-and-so told me to do this, okay, and you knew that it was wrong, okay, because you're taught before you go into those places, what's right and what's wrong. And I'm not taking up these some of these issues where we have ridiculous restrictions on engagement criteria. I'm not talking about that, but we don't allow our soldiers to use Nuremberg-like excuses of, hey, I was just doing what the captain told me, the lieutenant told me, sergeant told me. We don't hold that. That doesn't get them that's not a get out of jail free card. There are things that they know they're not supposed to do. Well, the same thing with our legislators, or should be the same thing. We don't want to hear, well, the judge said it, we have to do it. If they know good and well that the judge didn't have the authority to do that, they should be pushing back. Just like when this whole gay marriage thing happened, Our states, every one of our states should be pushing. In Tennessee, they should have been pushing back on our governor because within an hour and a half, our governor, Bill Haslam, of pilot fame, caved and ordered the clerk, not the clerk, but the state AG and everybody, hey, you guys got to start issuing licenses, marriage license to homosexuals. And you know, he should have been impeached. He should have been impeached because he didn't have the authority to do that even at the state level. But everybody went along with it, like you said. So that's sad that we allow them this get out of jail free card for, well, the court said. And so we have to do it. So
yeah, I'm really glad you mentioned that, Dave. And people need to understand too, when you swear an oath to uphold and defend the Constitution, typically you're putting your hand on a Bible. This is a sacred oath before God. In fact, many times the oath ends with "So help me God." You someday are going to give an account to God for what you did, and saying, well, the Supreme Court said we could murder babies, and I swore an oath to uphold the Constitution, and therefore we have to allow murder of babies. That's not going to cut it, right? God's going to ask you, what did you do to push back on that wicked decision? And the Nuremberg defense of, well, I was just following orders, that's not going to fly. It's not going to fly at all. Yeah. And so, folks, you have an even higher responsibility than your duty to your voters, your constituents, we the people. You have an obligation to God, and you need to be taking that really seriously. The Supreme Court now is treading in very, very dangerous territory, and they may be headed into even more dangerous territory if they are not stopped here soon. And every one of us is going to be held accountable for this. Every one of us is going to be dealing with the consequences of this lawlessness. And so we all have an obligation. And state legislators, people in state office, lower magistrates, you have an even higher obligation than we citizens to resist this, to expose this, to push back on this, and not to become a co-conspirator in this wickedness.
Absolutely. That's a perfect term, co-conspirator. I don't know why there's no good reason, in my opinion, we should continue to defer to the court. It's obvious that they have violated the Constitution over the years. And then what was once precedent is now no longer precedent, and now it's okay. I mean, that you look at that too. So they not only do they violate the Constitution, but whenever they decide to change their mind on something, everybody just goes along with it as if, for the last 20, 25 years, 50 years, we were doing it wrong, and now this is right. They really don't have any credibility, in my opinion. They're every bit as much of a problem, if not more, than our Congress. And matter of fact, they've facilitated a lot of what our Congress does. There's another aspect of this, and this has nothing to do with the book. And I do want to say, or the article, I do want to say that the guy, he is a good guy in a lot of ways. This is not meant to slam him. But these are a lot of the common arguments we hear, because they all come from, generally speaking, from lawyers, from most of your lawyers. And so that's why I wanted to address it. Plus, somebody brought the issue to me, so I'm like, okay, well, let's see how this stands up. He did bring up good points, and he was more honest on some things than I've seen other people write about articles. But I just thought it was important to kind of get these things out there. But another big issue right now, when you talk about how far are we going to take this deference to the federal government and the courts in particular. If you look at the situation down in Texas, you look at the illegal immigration situation, you look at the border, and Texas is finally doing what it has to do, or attempting to do what it has to do in terms of dealing with these people coming across the border. And a lot of that is because the Supreme Court has determined, without anything in the Constitution, they have determined that the federal government has total control on the issue of immigration. Now, the Constitution only mentions naturalization. It says nothing about immigration. There's nothing in there. Now, it does say the federal government is supposed to protect our states from invasion. Well, they're violating that because they are leading the invasion. And states have a right to defend themselves. And this extreme, this ridiculous deference to the court, where we allow them to say, well, hey, federal government gets to call all the shots on immigration, you're just out of luck. That's insanity. That's something that has to stop, and has to stop soon.
Yeah, you're absolutely right. And the immigration issue is another one. We're dealing with multiple existential threats here. We have a federal government that is actually waging war on our country. They are facilitating an invasion. They know full well that special forces from the People's Liberation Army of China are coming across that border. They know full well that jihadists are coming across that border. They know full well that a lot of these guys have the blueprints for our water treatment facilities, our sewage treatment facilities, our power stations. This is an actual invasion coming across the border, and states have an obligation to protect us from this invasion. So does the federal government. But if the federal government won't do its duty, well, the states certainly must come in and do theirs. And I want to add one more thing to this issue of the law and where it comes from, right? Right at the very top of the Supreme Court building, they've got the little triangle, and you've got Moses there with the Ten Commandments right in the middle. The law is something that transcends what five guys in black robes think about the law. If you read the legal scholar most quoted by our founding fathers, Sir William Blackstone, he wrote commentaries on the laws of England. He delves into this in great depth, right? When Thomas Jefferson talked about the laws of nature and nature's God, that had a specific meaning to the people who he was writing to. They had been reading Sir William Blackstone, one of the greatest legal minds probably of all time. And what he explained is that there is this natural law, and the law is revealed by God to human beings through creation, and more importantly through the Bible. And he says these laws are binding on all people everywhere in the world at all times, and no law that is contrary to the laws of God can ever be suffered even for a moment. So would the mass murder of unborn children under the guise of an imaginary right to privacy found in the penumbras of the Constitution be a violation of God's law? Well, of course it would be, right? And so this is a debate that has been had before, and it has been settled before, right? The English Civil War had a lot to do with this. In the 1600s, King Charles declared himself to be the supreme ruler. He wanted to dissolve Parliament. He didn't believe that he had to respect the rights of the people, which previous kings had already agreed to in the Magna Carta. And he said, you know what, I'll be the law. So the debate was Lex Rex, right? Is the law the king? Or Rex Lex, is the king the law? And we're now having this debate again. The question is the law the king, or is the Supreme Court the law? And the obvious answer is the law is supreme. The Supreme Court is not allowed to overturn the divine laws that God has revealed. And so when the Founding Fathers said you had an unalienable right from God to life, where'd they get that idea? Well, God said don't murder, therefore you have a right to life. God said government must punish evil, therefore government must punish murderers, therefore government must help you protect your life. Same thing is true with property. God said, thou shalt not steal, therefore you have a right to property. Stealing is evil, therefore government must punish thieves. So these are all fundamental truths that the people, when the Constitution was written, understood very clearly. We've now moved, unfortunately, after generations of dumbing down and indoctrination, we've moved a long way from those roots, but we need to get back to a proper understanding of what they meant. Nobody who wrote the Constitution, signed the Constitution, voted to ratify the Constitution in their state, would have imagined in a million years that we would have five clowns in black robes ruling that you could exterminate unborn babies and call it a right to privacy. It never would have occurred to them that we would become so unmoored. So we've got to fix this. We've got to recognize that there is a power that is higher than the Supreme Court. We've got, actually, during the War for Our Independence, our Founding Fathers flew these flags. They said, appeal to heaven. Right? When all of the human institutions are corrupt beyond hope, we need to appeal to a higher court, and there is a higher court. We need to appeal to heaven, and we need to understand that the Supreme Court cannot make these kinds of rulings. It is illegitimate, and everybody, from the state legislator down to the dog catcher, down to the lowliest poor citizen, has an obligation to resist.
Absolutely. Well, hey, I really appreciate you coming on the show. I'd love to have you back, and I can't thank you enough. And hopefully we'll find a way to get you back on here, and let me know when you're going to be in Tennessee.
Hey, it would be honored to come back on. Thank you so much, Dave. Thanks for what you do, and thank you for having me on the program.
All right, thank you. I want to thank, here's his website. This is Alex's website, Liberty Sentinel. There's great information on there, and that's definitely worth your time to take a look at. I want to thank you all for taking the time to watch our program. Be sure to hit the like and subscribe buttons, as well as the notification bell, to stay informed about our upcoming shows. We have a surprise for you tonight with our first ever Two for Tuesday. After the show ends tonight, we have another guest on another important topic. Tonight at 8:30, we'll have Courtney Turner from the Courtney Turner Podcast here to talk to us about NACs, which are natural asset companies, and the threat they pose to our property rights, our prosperity, and our national security. And this issue might be decided this week, so please join us again tonight at 8:30. As a reminder, you can now listen to us on podcast@spreaker.com. You can find all the audio-only podcasts on your favorite episodes on our website, teeninformer.com, or do a web search for Tennessee Informer on Spreaker, where you can also download the Spreaker app for Android or Apple phones. We've also are excited to announce the Tennessee Informer podcast are now available to listen to on iHeartRadio, Spotify, Amazon Music, Google Podcasts, and several other platforms. There are ways to watch and listen, so stay tuned as we grow and share the message. Also, take a moment to check out and follow our Facebook page, Tennessee Informer. We're posting a lot of news and information on there, as well as on our website, teeninformer.com. You can sign up for a weekly newsletter. We're on Twitter now as well at twitter.com/teeninformer. Share us with your friends so they can stay informed on what's going on. Our guest next week will be Matt Throckmorton, a former executive director of the Tennessee Charter School Association, here to talk with us about the negative effects of social emotional learning on our children. Also, before Matt Throckmorton on Monday, on Friday we have a special show with Bill Warner. It was a pre-recorded show. It will be this Friday at 7 o'clock. Bill will talk to us about sex and Hamas. It's an interesting show. You'll want to tune in for that. And then back to Matt Throckmorton. He will be here Tuesday on the 23rd, and he'll be talking about social emotional learning and the damage it does to our kids in the schools. That's it for tonight. Good night from Paris, Tennessee, that is.